Welcome to the Ache and Gump webinar. Do you need protection from the Paycheck Protection Program, avoiding False Claims Act liability in connection with the PPP? My name is Angela Stiles, and I will be your moderator for today. I'm a government contracts partner in the Washington, D.C. office. I am joined by three colleagues, Scott Heimberg, Lizzie Scott, and Mike Warnicke. Scott is a partner in the Washington office. He's been practicing in the area of government contracts for close to 35 years and has handled numerous False Claims Act cases relating to government contracts and grants, including the purchase of high-tech and pharma and construction services. Lizzie Scott is a partner in the Dallas office whose practice focuses on the defense of lawsuits filed under the Federal False Claims Act and its state's equivalent. Lizzie also represents companies in securities and privacy litigation, consumer class action, internal investigations, regulatory investigations, and other enforcement proceedings. In 2018, Lizzie was recognized by Law 360 as one of the 5 rising stars in government contracts. And last but not least, Mike Warnicke is a partner resident in the Dallas office who focuses on government investigations and related civil and criminal litigation. His matters typically involve the Federal False Claims Act, antitrust fraud, and other regulatory compliance issues. Along with our co-panelists, Mike is working to defeat one of the largest onslaught of federal and state False Claims Act Qui Tam actions against a single defendant in the Act's history. As all of you know, the PPP was enacted by Congress and signed by the President in late March of this year. Applications opened up in early April, and it was nothing short of rush for what was perceived as free money, with many companies not realizing that there were fairly restrictive eligibility rules. Because the PPP is embedded with an existing program, the FCA's 7A loan program, it came with a host of underlying regulations that have been interpreted by the Office of Hearing and Appeals at the FCA and the courts for many years. Here today, we're going to discuss the basics of the PPP program, including these many underlying rules and new rules, as well as FAQs that have been issued. The False Claims Act basics, the PPP highest risk areas, most of which we've discovered working with probably over 100 clients at this point since the enactment of the PPP, as well as our time where we've spent working with government contract clients under similar FBA rules that govern government contractors that are very similar to the FCA's 7A loan program. And finally, we're going to discuss risk mitigation strategies. We're going to start with the basics of the Paycheck Protection Program. I'm sure most of you know those basics pretty well by now. What I think is fairly unusual is the last bullet on this slide, that 75% of the loan proceeds must be used for payroll. This was not actually in the CARES Act when it was first added, when it was first adopted. It was added by a first interim final rule and has been fairly controversial to date. What you probably also don't know is that since enactment of the CARES Act, there have been more than 11 individual interim final rules. There have been 47 FAQs. And we're going to talk at length later about the nature of the FAQs versus the regulations that have been issued versus the underlying 7A regulations that govern the 7A loan program. These are in addition to significant case law under the 7A loan program and SBA standard operating procedures. To say it's confusing and that there's conflicting guidance would be an extraordinary understatement. So let's start with the first area of eligibility under the PPP. First is that the entity that is applying for the PPP loan or the forgivable loan must have fewer than 500 employees, and that includes affiliates. We'll talk more extensively about what affiliate means in a few minutes. Interestingly, also, hotels and restaurants of all sizes were originally given access to the PPP program. So even entities with more than 500 employees, so hotels and restaurants operating in NAICS Code 72 with more than 500 employees but less than 500 per physical location were eligible. Franchises, the alternative size standard as well, which is an unusual one and hasn't been used very often in the past by the FCA. So if you've got a tangible net worth of not more than $15 million and average net income for the past 2 full fiscal years of not more than $5 million. And then finally, also nonprofits, which have historically not been eligible under the small business programs. Now, what's really important for the purposes of entity eligibility is how you count employees. So average employment is going to be one of 2 periods, calendar year 2019, or each of the full pay periods preceding the 12 calendar months from when you actually apply. 2 other pieces that are important here. You have to count domestic and foreign employees of all affiliates. A lot of people did not understand that in the beginning. And part-time employees are counted as full-time employees. And with that, I'm going to turn it over to Scott Heinberg to talk about affiliation.
Thank you, Angela. As Andrew just stated, a company seeking a PPP loan must determine whether it qualifies as a small business under the applicable size standard. The loan applicant must look at not only its own size, but include its affiliates as well. For example, if operating under the 500 employee ceiling, it would need to add its employees to the head count of its affiliates to conclude whether it indeed qualifies as a small business. To do this, the loan applicant must determine if it has affiliates. The CARES Act didn't provide guidance on determining affiliation, but the SBA's regulations under its 7A loan program do provide some guidance on affiliation. The SBA's rules state that concerns and entities are affiliates of each other when one controls or has the power to control the other, or a third party or parties control or has the power to control both. It doesn't matter whether control is exercised so long as the power to control exists. So in other words, you look both down the chain of ownership and up the chain of ownership. Now, looking down is obvious. If an applicant has a subsidiary, it gets counted as an affiliate. But looking up the chain is not always as clear regarding who counts as an affiliate. The SBA regulations address this to some degree. They say that a concern is an affiliate of an individual concern or entity that owns or has the power to control more than 50% of the concern's voting equity. So in other words, if an investor has greater than 50% ownership of the business, that investor is considered an affiliate of the business or the loan applicant. The SBA also addresses what happens if there's a minority investor in the loan applicant and looks to negative control. So the SBA will deem a minority shareholder to be in control of the loan applicant if that individual or entity has the ability under the concern's charter, bylaws, or shareholders agreement to prevent a quorum of the board or otherwise block actions by the board of directors or its shareholders. Now, what does it mean to have common negative control? In determining negative control, the SBA looks at whether an investor can block ordinary operations of the company rather than extraordinary actions of the business. So we've listed here 14 different areas that the SBA has reviewed and over time concluded constitutes ordinary operations of the company. Now, I'm not going to review the entire list, but I will point out some of the rights that we've seen come up over and over again in our counseling of clients on affiliation. So the first one that I want to point out is the disposition, sale, license, or transfer of any assets. That is something that is typically included in rights that an investor gets in controlling the business or having the ability to block certain sales. So the SBA has looked at that and concluded that disposition of substantially all the assets is an extraordinary action, while the disposition, sale, or license or transfer of assets of the business, when it's not substantially all the assets, constitutes an ordinary action of the business. And if an investor has the ability to block those ordinary actions, the SBA has concluded that it has control and it is in fact an affiliate of the business. The same is true for a declaration or payment of dividends, which the SBA has looked at and concluded is an ordinary action of the business. The same is true for number 8, hiring or firing of the president, the CEO, the CFO, or in fact any C-suite executive officer and other management level employees of the business. The SBA has also concluded that the approval or adoption of annual budgets is an ordinary course action, as is approval of any new capital expenditure program or any capital expenditure. So any investor that has the rights to block those certain actions or direct the company to take certain actions will be considered an affiliate of the business. Once an investor is determined to be an affiliate, the next step is to look at other companies that are controlled by that same investor. So employees of the investor are counted, of course, as affiliates and must be added to the loan applicant's business, as are the companies that are controlled by the investor and all of their employees. They too have to be added to the headcount of the loan applicant. Later in the presentation, we'll discuss how this affiliation determination creates a risk under the False Claims Act. But for now, I'll hand it back to Angela for further discussion.
Thank you, Scott. What you're looking at here are the required certifications. So when you submitted your application for the PPP, you made a number of certifications. These two, for the purposes of the False Claims Act, are probably the most important certifications you made. The first one has to do with economic need. And what's very important about the first one is it is word for word what was in the statute and required to be made for all PPP applications. It also appeared word for word in the interim final rule. And as we discussed the FAQs that came after the statute and the final rule, that will become very important, particularly with regard to the use of the brand memo, which we'll talk about as well. The second certification on this slide is a certification that you are eligible. So all of the issues that we're talking about here, whether you're eligible or not, whether you're affiliated, whether you're an eligible business, whether you've made the certification correctly, all relate back to whether you are eligible under the statute and the regulations, and then you certified this on your PPP application. So things got pretty interesting, I must say, when public companies that have accepted PPP loans or filed PPP loans, either one because they fell into both categories, made their required SEC filings and revealed that they had applied and or accepted PPP loans. So you will have heard about Shake Shack and Roostress, public companies that under the certification that you saw, under the eligibility regulations that you saw, under the statute and the regulations, were eligible for these PPP loans, filed them, and then faced extraordinary criticism in the press and frankly from the administration as well, stating that they had access to additional capital and therefore it was inappropriate, not that it was illegal, but it was inappropriate for them to be accessing PPP loans. You saw Secretary Mnuchin making several comments about it, and then you also saw the release of this particular FAQ. And this is where we'll get into talking about the difference between the certification of need in the regulations, the application, and the statute versus this FAQ. This FAQ changed the standard from what most people who had originally applied for PPP thought the standard was for their certification of need. And I will tell you, it has had a fairly significant chilling effect on the number of people that are applying and the number of entities that have actually decided to give the money back as well. Additional guidance has also been issued since FAQ 31 came out. The SBA and the Department of Treasury have stated that if the loan is less than $2 million, they're going to deem that the certification of need was made in good faith. So as a general proposition, if your loan at the time of your application, including all of your affiliates, so everyone in your corporate group, was less than $2 million, then they're going to presume that you made a certification of need in good faith. For companies with loans greater than $2 million, they're going to be going through much more significant review from the SBA. And I think very importantly, if we take a look at the last bullet, the SBA has backpedaled a little bit on the certification of need. If you have a loan that's greater than $2 million, which includes your entire corporate group, at the time you seek forgiveness, you're going to go to the SBA. You're actually going to tell your lender first because the lender is your first line here. You're going to take your forgiveness form to the SBA. They're going to work with SBA. They're going to determine if your certification of need at the time of your application was sufficient or not. If the SBA finds that your certification of need was not sufficient, you can simply repay the loan at that point in time, and SBA has stated that it will not pursue additional administrative enforcement or referrals to other agencies based upon your certification of need. Now, if you decide you would like to challenge their decision, you would need to take that to federal district court. So another area to pay attention to in the PPP is the appropriate use of loan proceeds. The first and most important item, unless it's changed by Congress, the proceeds must be spent by June 30th. A lot of people don't realize that is requirement is in the CARES Act. 75% must be spent on payroll, although there has been some discussion because that was implemented by regulation of backing off that a little bit. But for right now, 75% of the loan proceeds must be spent on payroll. The rest of it are fairly straightforward in terms of what allowable uses through June 30th, 2020 will be for PPP proceeds. But there are also inappropriate uses of PPP proceeds, as we've seen frequently in the press.
Now, this has a lot of people talking this morning, so we wanted to make sure you didn't miss it. A cast member of Love and Hip Hop Atlanta is now accused of taking federal money meant to pay employees, spending it on himself. It's the top story on our website. The FBI says Maurice Fain, known as Arkansas Mo, applied for a $2 million loan from the Paycheck Protection Program, but they say he used more than $1 million to buy expensive jewelry, including a Rolex, also to pay for child support. The Justice Department says Fain is facing federal fraud charges now.
So another area to be aware of is public disclosure. Loan information and the applications are subject to the Freedom of Information Act. In fact, 5 press outlets, including the Washington Post and ProPublica, have already filed lawsuits for the release of the information. SBA has said that in the following weeks, probably the next 2 weeks, they will be releasing basic loan information from their E-Trans system. It should include applicant name, loan amount, lender, approval date, NAICS code. It comes straight from their legacy system. Traditionally, it's been downloaded into an Excel spreadsheet that people are able to pull up and look at. So people should be aware that although for the moment it is not obvious who all the applicants are and who the people are that have also returned funds, it will be in the next several weeks, and then eventually the loan applications will in large part be available through the Freedom of Information Act. And one final item is forgiveness. Just last week, late on Friday, the Small Business Administration released a loan forgiveness application. It is 11 pages long. It is fairly complicated. Based upon our review of it, there will probably be some updates to this as well. Also important to remember is the safe harbor provisions. So there are some safe harbor provisions that are implemented if you reemploy everyone that you had employed on February 15th by June 30th of this year, as well as keep their compensation at the same level. Those safe harbors were in the statute, and this is the first guidance we've received on safe harbor. But with that, I will turn it over to Lizzie.
Thanks so much, Angela. We wanted to go ahead and start our introduction to the False Claims Act with a slide on why every company that deals with federal funds should be interested in the FCA. The FCA is the federal government's principal civil anti-fraud statute. and it imposes treble damages and penalties for the knowing submission of false claims, the use of false records or statements material to a false claim, or the concealment of an obligation to pay. And since a substantial amendment to the Act back in 1986, the government has recovered over $62 billion under the False Claims Act. And in 2019 alone, the federal government obtained over $3 billion in settlements and judgments under the Act. Now, when most people think about the False Claims Act, they may think about the healthcare industry. And the healthcare industry is certainly a large area under the FCA. For example, in 2019 alone, for the 10th consecutive year in a row, there were over $2 billion in FCA settlements and judgments in the healthcare industry. But the FCA extends far beyond the healthcare industry to basically any entity that does business with or receives money or property from the federal government. And we've included on this slide a list of some of the industries in which we've seen FCA activity. And we think the PPP program will only further extend this list to additional companies and industries. Before we get into the elements of an FCA claim, we wanted to provide a brief historical overview of the Act. And we've included a photo of Abraham Lincoln on this slide because the FCA is sometimes referred to as Lincoln's Law. This is because it was passed in 1863 during the Civil War and was in response to allegations that the U.S. government was being billed for non-existent or worthless goods. The classic FCA case at the time was an allegation that the government was billed for artillery shells or rifles, but what it actually received was just a box full of sawdust. And as we will discuss as the presentation goes on, we think the False Claims Act has been extended well beyond these original types of cases. One additional historic note that we wanted to mention is that the False Claims Act includes a whistleblower provision. And we'll discuss this provision in further detail as the presentation goes on. But the Act included this provision because at the time the Act was passed, the government didn't think it had the resources or the centralized federal agencies like the current DOJ to actually enforce the Act. So it felt a whistleblower provision that allowed private parties to bring claims was essential. Let's turn now to the elements of an FCA claim. The first element is falsity. The False Claims Act requires that the defendant make a false statement or engage in a fraudulent course of conduct. This could include presenting or causing to be presented a false or fraudulent claim for payment or approval, or making, using, or causing to be made or used a false record or statement. In the PPP context, the falsity element will obviously include looking at the statements that are actually made in the loan application. In addition to express falsehoods, the False Claims Act also includes failure to disclose information under certain circumstances. In 2016, the U.S. Supreme Court decided the Escobar decision, which is a really important decision in the False Claims Act space. And that decision confirmed that express falsehoods are not necessary for FCA liability, and that misrepresentations by omission may give rise to liability under an implied false certification theory if a couple of different conditions are met. First, the claim must not merely request payment, but it must also make a specific representation about the good or service that's provided. And then second, the defendant's failure to disclose non-compliance with a requirement must then make that representation that was made a misleading half-truth. Knowledge is the second element of an FCA claim. The FCA prohibits a person from knowingly presenting or making a false statement or record. And the FCA defines knowingly as either actual knowledge, acting in deliberate ignorance of the truth or falsity of the information, or acting in reckless disregard of the truth or falsity of the information. Significantly, proof of a specific intent to defraud is not required under the Act. With respect to the knowledge element in the PPP context, given the complexity of some of the affiliation rules that we're discussing today and the constantly changing guidance that's been provided to the PPP program, we think many defendants may have a good argument that plaintiffs cannot meet the FCA's knowledge standard because the defendant had a reasonable interpretation based on the guidance that was available at the time. And we'll explore this in a little bit of additional detail as the presentation goes on. Materiality is the third element of an FCA claim. A false statement must be material to the government's payment decision to be actionable under the FCA. The statute defines material as having a natural tendency to influence or be capable of influencing the payment or receipt of money or property. The materiality element is another area where the Supreme Court's Escobar decision is significant. And in Escobar, the Supreme Court confirmed a couple of things. It confirmed that the materiality requirement is rigorous and demanding. It confirmed that the materiality requirement is not too fact-intensive to be decided at the motion to dismiss or the summary judgment phase. And it confirmed the importance of the government's actual payment decisions and actions on the materiality inquiry. Thus, under Escobar, if the government pays a claim in full despite its actual knowledge that a requirement was violated, that is very strong evidence that the requirement was not material to the government's decision. Similarly, if the government regularly pays a claim in full despite actual knowledge of a violation and has signaled no change in that policy, that is also very strong evidence that the requirement was not material. Finally, the FCA includes a causation requirement, and false statement or conduct must have caused the government to pay out money or to forfeit money due for it to be actionable under the False Claims Act. In addition to the elements of an FCA violation, we wanted to note a couple of special False Claims Act circumstances that we think may end up being relevant in the PPP context. And the first is the reverse False Claims Act violation. In addition to the context that we've already discussed in which an FCA violation may occur, the FCA also prohibits making or using a false statement or record to improperly withhold funds or property from the government. In the PPP context, we think the reverse FCA provisions may be used to capture improper applications for loan forgiveness or the knowing retention of loans where ineligibility is realized after the safe harbor period expires, but the loan is not repaid. Additionally, we wanted to note the conspiracy provision that's included in the Act. And this provision may be used to loop in remote players like owners, investors, or affiliates of a company involved in an FCA case. And even before the PPP program, we saw some additional activity by the government in this area, including bringing cases against private equity backers related to activity by their portfolio companies. So this will be another area to watch in the PPP context. Finally, we wanted to note that the FCA does include a retaliation provision that imposes liability for retaliating against an employee that raises an FCA claim. We'd like to turn now to FCA defenses. And while we don't plan to cover all available defenses under the Act, given the significant amount of information that we think is going to become public with respect to the PPP program, as Angela discussed earlier, we wanted to cover the FCA's public disclosure bar. Under the original FCA, relators could bring actions based on a pre-existing government indictment or investigation and then use that action to recover a large cash bounty. Ultimately, Congress recognized that this type of lawsuit didn't really advance the objectives of the FCA, so Congress amended the Act to bar suits that were based on evidence or information that was already within the government's possession. And this was originally the government knowledge defense. And then in 1986, in connection with those substantial amendments to the Act, this government knowledge defense was then replaced with the public disclosure bar. Under the current version of the public disclosure bar, actions that are based upon certain publicly disclosed information are subject to dismissal. So for the public disclosure bar to apply, a couple of requirements must be met. First, the disclosure must be made in a qualifying public forum. And we've included here on the slide the qualifying forums, which most notably includes news media, which is an area where we see a lot of activity. The disclosure must also be sufficiently specific, which means that substantially the same allegations or transactions that are alleged in the action must be in a qualifying public disclosure. If both of these requirements are met and the public disclosure bar applies, you can still avoid dismissal of the action if the plaintiff can show that he's an original source. And this means that he's an individual with knowledge that is both independent of and materially adds to what has been publicly disclosed. Now, there are two notable exceptions to the public disclosure bar. First, the bar doesn't apply to any actions that are brought or prosecuted by the federal government. And additionally, under the 2010 version of the FCA, the government has discretion to block the dismissal of an action under the public disclosure bar if it should choose to do so. Turning to FCA damages and penalties, False Claims Act violations are punishable by civil penalties plus 3 times damages. And one question we foresee in the PPP context is whether the FCA damages would be the total value of the loan that was obtained or only the total value of the loan that is ultimately forgiven. Additionally, one note we wanted to make here is that a successful False Claims Act plaintiff is entitled to his attorney's fees and costs, and this is in addition to the substantial bounty that's available under the Act as damages. So there's a significant incentive for a relator to bring a case. And with that, I would like to turn things over to Mike Warnicki, who will discuss the False Claims Act Qui Tam provisions in some additional detail.
So as Lizzie noted, False Claims Act cases may be brought directly by the federal government or by private citizens under the False Claims Act Qui Tam provision. This is the classic whistleblower provision in the Qui Tam law. These suits are different than your typical civil lawsuit in a couple of important ways that this slide gets into. They have different terminology, relator versus plaintiff. The government can choose to intervene in the case or join the case or not. The relator files the case under seal to give the government time to investigate the allegations and decide whether or not to intervene in the case. That seal can be extended many times to allow a robust investigation. During that seal, the federal government could be interviewing the whistleblower, other witnesses, issuing subpoenas, hiring experts, conducting a robust set of discovery completely under seal. Another interesting feature of the Qui Tam provision is the recovery provided to relators, which can be in the millions of dollars. Some of the recoveries out there are literally life-changing, lottery-level recoveries. And so the incentive structure that is available to whistleblowers is quite powerful and obviously by design under the Act. The other interesting feature of the Qui Tam provision is that these cases can actually be difficult to settle because you've got multiple plaintiffs, 2 to 3, depending on how you consider it. You've got the federal government represented by the DOJ. You often have an agency that is the affected agency or the subject matter expert for the issues involved. And then you also have the whistleblower, him or herself. All of those folks have their own lawyers as well. So you can have multiple parties with multiple competing interests on the other side of the V as you're trying to reach a resolution. And so these cases can go on for years and be quite expensive. Also, there can be differences in incentives and positions between the relator and the federal government on whose behalf the relator nominally represents, and those differences can delay resolution, complicate the ability to reach a settlement with the government. So Qui Tam actions are quite important to the regulatory scheme. Out of the $3 billion of False Claims Act recovery that Lizzie mentioned the government received in fiscal year 2019, 2.1 billion of the three was a result of Qui Tam lawsuits. There were 633 of them filed in fiscal year 2019, which is 12 per week, versus only 146 non-Qui Tam False Claims Act cases. So this provision is quite important to the government's regulatory framework. It is quite popular with both political parties, and they've become so powerful that, in fact, that the Department of Justice has actually had to reiterate that it will dismiss meritless Qui Tam actions when appropriate, given the number of cases being brought. So often, companies will find out that they have a Qui Tam filed under seal against them quite by surprise. The most concrete indicator that there may be a Qui Tam against the company is a receipt of a CID or other type of subpoena or other type of inquiry from a government agency asking about the various issues involved in the Qui Tam lawsuit. That's probably the most concrete signal that you may have a Qui Tam, but it's not the only one. There are also other conditions that, while they don't necessarily indicate that you have a Qui Tam or will in fact receive one, they do provide a framework or conditions that are ripe for Qui Tams to arise, and some of those are listed on this slide here. I'll say most employees probably want to do the right thing. They want their companies to do the right thing. They aren't looking to find problems and become whistleblowers. And so chances are there are some indicators within the corporate structure and within the discussion of the issues internally that indicate a disagreement arising or frustration arising, and being sensitive to those situations may allow you to resolve issues before you have a whistleblower. And as Lizzie mentioned, whistleblowers do have protection for retaliation claims, so you must proceed very carefully when you suspect you have a whistleblower, especially one that is still employed by the company.
So thank you, Mike. This is Scott, and we have looked at some of the requirements of the PPP loan program, and we've also taken a look at the coverage of the False Claims Act. So we now turn to areas that could cause risk under the False Claims Act when applying for a loan and receiving a loan under the PPP program. So receiving a loan under the program while being an ineligible business based on the nature of the business could cause a False Claims Act case to arise. The same with not being a small business based on affiliation, which we discussed earlier, or otherwise. Being an ineligible business based on exceeding the 500 employees, again, not being a small business. Improperly certifying that you have a need for the loan when in fact you have available capital or other resources to tide you over during the period of uncertainty during the COVID virus emergency. And then improperly using the loan proceeds for things that are not permitted under the PPP program. So on this slide, we see a list of ineligible businesses. And before we get to that, there are other things to note. There are a few issues that could prevent a business from receiving a loan and create FCA, or False Claims Act liability, if misrepresented on the loan application. One is, and these appear directly on the loan application form itself. If you're a suspended or debarred company, meaning that you're ineligible for government contracts or government grants, you are ineligible to receive a loan under the PPP program. Similarly, if you are in bankruptcy currently at the time you are submitting your loan application, you're ineligible to receive the money under the loan program. If you're indicted presently, or you've been convicted of a crime in the last 5 years, you are ineligible for the loan program. Or if you engage in a business that's illegal under federal, state, or local law, you're ineligible for the loan program. So those are things that appear directly on the loan form application itself. Now we turn to the list that's on the slide in front of you. These ineligible businesses don't appear anywhere in the CARES Act. These are things that the SBA has articulated after the statute passed to say that if you're in these businesses, you are ineligible for the award of a loan, at least under the PPP program. So the ones that have caused, I think, the greatest amount of heartburn in this list here are hedge funds and private equity. So we've received a number of calls from clients who are actually funds, or whether it's a hedge fund or private equity fund, or manage those funds, and sought to receive a loan because they otherwise are eligible to have fewer than 500 employees, and otherwise believe they had a need for the money. But the SBA has reviewed those types of businesses and concluded that they are in fact not eligible to receive the funding. For political or other reasons, the SBA has determined that the money shouldn't go to those types of businesses. Similarly, financial businesses primarily engaged in the business of lending, such as banks, finance companies, and factoring companies, are ineligible, as are life insurance companies, but not independent life agents, insurance agents, investment companies. For obvious reasons, businesses located in a foreign country, since the program is to get people employed in the U.S. Businesses primarily engaged in political or lobbying activities. And probably the most interesting one on this list are businesses that present live performances of prurient sexual nature, which one of my smarter partners had to explain to me was actually strip clubs. These ineligible businesses, if you are one of these businesses and applied for a loan and received money under the loan program, that money should be repaid immediately, because in the eyes of the SBA, the Department of Treasury, and the Department of Justice, you are ineligible to receive that money. Alternatively, you can seek injunctive relief in federal district court, and I'll explain that as we turn to the next slide. So we mentioned the strip club not just for prurient interest, but actually because of some legal precedent that we wanted to point out. In DV Diamond Club of Flint, which is a strip club in Michigan, they were denied access to the loan program by the bank and by the SBA, being that they were on the list of ineligible businesses. They filed for injunctive relief in the courts in Michigan, and the court granted preliminary injunction, finding that the SBA regulations on ineligible businesses actually conflicted with the clear mandate of the CARES Act, that all businesses of fewer than 500 employees were eligible for the PPP program. If you are, as I said before, if you are one of those businesses that are ineligible, perhaps hope is not lost. If you want to take action in court, you may be able to seek injunctive relief. Now, the relief that was granted in the Diamond Club of Flint actually required the SBA and the lender to accept the loan application of the Diamond Club, but that was a one-off, and it didn't have a nationwide injunctive relief for other businesses who are on that ineligible list, or even other strip clubs in other locations. So again, you would have to bring action in your local jurisdiction to seek injunctive relief to get your application considered by the bank and granted by the SBA. We've also previously discussed being ineligible based upon affiliation, or at least counting up the heads of your affiliates to determine whether you're a small business. As we suggested before, it's really incumbent upon the loan applicant rather than the bank or the SBA to determine whether the company actually qualifies as a small business. In order to do that, You want to review your majority and minority owners at all levels to determine, who's an affiliate of the business. All majority owners, as we said previously, are affiliates of the business, the loan applicant, and their employees must be counted for the applicant's eligibility. Again, you want to review the rights of all the minority owners to determine whether they have certain blocking rights of ordinary actions of the business, and therefore would be considered an affiliate, even though they're a minority owner. It's a very complicated area, so we suggest, as it would be no surprise coming from lawyers, that anybody seek legal counsel to determine if minority owners have the negative control rights that create affiliation and what that may mean to your business. And then we also want to look at review common management. We also want to look at common management with other entities to see whether the same set of managers are managing your business and other businesses. And if you do have the same set of common management, it could result in the SBA finding affiliation with those other businesses that are being run by the same individuals. So that's another possibility for affiliation, and another could result in the company being not considered a small business and being ineligible for the loan program. So this affiliation area has been a real cause of heartburn for companies that are owned by private equity. As we've discussed, it's not always self-evident that an investor is an affiliate. And further, it's not always clear whether the affiliation results in a company seeking a loan that is no longer being considered small enough to receive that loan. And for these reasons, there's real potential for False Claims Act exposure and the ability of either the government to challenge your eligibility, or as Mike was describing, a Qui Tam relator filing a False Claims Act case on behalf of the government and raising these issues, him or herself. With that, I'll turn it over to Angela to discuss the issues with counting employees.
So who would have ever thought that actually counting the number of employees you have would be quite so hard? The CARES Act itself is very clear that businesses with fewer than 500 employees are eligible. You can also have more than 500 employees if your underlying SBA size standard is larger. So there are some businesses, manufacturing businesses, that have 1,000 or 1,500 employee standards. So it's always important to take a look at that. And some of the standards are based on revenue as well. There's also the alternative size standard that we spoke about earlier. But I will tell you, this 500 employee standard has been very, very hard in application. A lot of subsidiaries of other companies simply looked around at each other in their building and said, gosh, we only have 100 employees here. We must be eligible, without asking any additional questions. It was not clear on the application that you had to do anything more if you were a subsidiary than simply put down the number of your employees that were sitting in your subsidiary's building and write those down and make your application. And lots of companies did. They didn't include foreign employees. They didn't include employees from their parents, from sister entities. They didn't include employees of affiliated entities that Scott was just talking about. And they didn't count their part-time employees as full-time. So there's many companies that, in the rush to get applications in, just looked, to each person in the building and said, we've got less than 500, let's get our application in. Another very significant issue that we've encountered is the proper time period for counting employees. Again, not on the face of the application is the proper time period for counting employees. So many people applying in April had already laid off or furloughed a number of people. They looked at the employees for their entity on that day of application, instead of realizing that the underlying regulations had two time periods that had to be used. You couldn't just look around on that day and say, oh, we fired 100 people, so we're at 475, so we're clearly eligible. So you also had to have looked at the proper time period. I will say that it is very important to go back and look at this. There are many companies that are still just realizing that they did not count the employees correctly. Go back, look at all of the affiliated entities, parents, subsidiaries, minority shareholders, majority shareholders, count part-time as full-time, and make sure that you meet this standard, unless you're a restaurant or hotel, because there is a very different standard that applies to them. If you exceed that standard or the other applicable one for your particular industry, you will need to repay the loan proceeds immediately. There may be one exception to returning the funds if you miscounted employees, particularly employees of foreign affiliates. On Monday, the Small Business Administration posted in the Federal Register reading room a draft interim final rule that states, because there was great confusion over the counting of foreign employees, that if an entity applied for a PPP loan before May 5th, 2020, that they do not have to return the funds if they simply improperly counted foreign employees at foreign affiliates. This rule does not become final until May 21st, but if it does become final in this form, there will be one particular instance where PPP applicants may be able to keep loan proceeds where they improperly counted employees. The other area that's been quite troubling for companies is this certification of need. You may recall from the prior slides that the statute and the regulation, as well as the application, required a certification that current economic uncertainty makes the loan request necessary to support ongoing operations of the applicant. That is the certification that companies made when they submitted the application. We worked with a number of companies at the time of their submission to make sure that they were documenting their need on that day. You know, what have you experienced so far? How much revenue have you lost? How many people have you already laid off? What is your cash on hand? What is your available credit? Can you sell additional equity? Then we were confronted with FAQ 31, as well as statements by Treasury Secretary Mnuchin about a different standard. So we had statute, regulation, application with one standard, and we had Secretary Mnuchin, after it was revealed that public companies applied for PPP loans, who came up with a different standard that you find in FAQ 31 and also some of Secretary Mnuchin's statements that appear to apply an access to credit standard, something of a stricter standard. This has raised a lot of questions from the perspective of what is the actual legal standard versus how you've seen a reaction in the press, a reaction to public criticism for particular applicants alone. So I'm going to turn it over to Lizzie to talk about the brand memo and the actual impact of an FAQ versus a regulation or a statute in and of itself.
Thank you, Angela. So as Angela just noticed, the speed with which the PPP guidance has changed has been nothing short of amazing, with guidance seemingly changed even on the fly through comments to the press, which we think is demonstrated by the following video regarding statements that Steve Mnuchin has made.
It is unfortunate that there's a small number of companies that have created a lot of publicity that took loans. I think it was inappropriate for most of these companies to take the loans. It was clear there was a certification. We don't think that they ever should have been allowed to. We put out an FAQ clarifying the certification and saying that if they paid back the loans in 2 weeks so that we could reprocess that money, they would have no liability. Otherwise, they would have liability. And I must say, I'm encouraged by the number of people that have paid them back. I never expected in a million years that the Los Angeles Lakers, which I'm a big fan of the team, but I'm not a big fan of the fact that they took a $4.6 million loan. I think that's outrageous, and I'm glad they've returned it, or they would have had liability. And let me just say, I'm going to be putting out an announcement this morning that for any loan over $2 million, the SBA will be doing a full review of that loan before there is loan forgiveness. So we will make sure that what was the intent for taxpayers is fulfilled here.
In light of this whiplash of changing guidance, we wanted to spend some time talking about the brand memo, which we think will be important in the PPP False Claims Act context. The brand memo was issued in January 2018 by then AAG Rachel Brand, and it deals with the use of guidance documents interpreting federal statutes and regulations, and it limits the manner in which the government may use those documents. The brand memo provides that DOJ will not use its enforcement power to convert guidance documents into binding rules, and that it will not use non-compliance with guiding documents as a basis for proving a violation of certain laws, specifically including the False Claims Act. And when the memo refers to guidance documents, it's referring to any agency statement of general applicability and future effects, whether or not that statement is called guidance or otherwise, that is designed to advise parties of their legal rights and obligations. And guidance documents could include letters to industry, policy manuals, handbooks, and even frequently asked questions. Now, significantly, the brand memo does not eliminate the relevance of guidance documents altogether. The memo does provide that guidance documents may still be used to explain or paraphrase existing statutes, and they may still be relevant as evidence of materiality or scienter under the False Claims Act. But the memo does make clear that guidance documents will not be used to prove a violation itself. And with that, I'd like to turn things back over to Mike to discuss some risk mitigation strategies in the PPP context.
Thank you, Lizzie. So as you know, the safe harbor deadline to return funds improperly received has passed, but that is largely irrelevant to what you should do and the considerations you should make going forward. If you determine that there is an issue with your eligibility or the amount of the loan, or later on in the loan forgiveness phase, how the loan was utilized, that is a fresh clock to be considered for what actions the company takes at that point. You can argue that the risks now are even higher than they were before when the safe harbor was still an option. Without the safe harbor, liability could ensue for keeping the funds improperly. Government agencies at least purport to place a high degree of credit on companies' self-reporting issues, and we would expect generally that to be the case here, given the high volume of loans, the high-profile nature of the program, the very political nature of the program, the heavy media scrutiny. Companies need to weigh the pros and cons of self-reporting an issue immediately versus taking a risk that an issue comes to light later. And it may well be that it's better to deal with it up front. Generally speaking, you'll have more control over the situation and possibly achieve a better result, even though it might not be any quicker doing it that way. There will also be a lot of effort to ferret out improper uses of these funds. There's new federal Inspector General task force. There will be an active effort by the Relators Bar to find cases to bring. So there will be a lot of scrutiny, and as Angela mentioned earlier, your company's name and the amount of loan you received and perhaps other information over time will come to light, and that will be poured over in detail by these groups. So it's very important to consider making the best of a period in time where you discover something and are able to create a brand new fresh record of good faith and compliance that could go a long way to proving your good faith and compliance all along, even if there was, in retrospect, a miscalculation along the way. There is criminal liability for fraud, obviously, and some of the statutes that could be implicated by PPP fraud are actually listed on the loan application and loan forgiveness application, though those are not all of the potentially relevant statutes. Some have periods of incarceration up to 30 years. So these are quite serious. Hopefully, these are issues that you will steer far and clear from. The cases that have been brought to date, and they've been brought with blistering speed, have been for individuals who filed loan applications for companies that had 0 employees. And the government was very quickly able to confirm that by going to the various state workforce commissions and looking at corresponding payroll records to determine that these entities had no employees or payroll. So those are obviously extreme cases, relatively easy to ferret out, and have already been brought. But going forward, there may be more nuanced cases that are generated in terms of criminal intent at the time of the loan application. Was the company planning to close in any event, or file for bankruptcy soon, or fire all the employees before the loan application was filed, such that they knew the loan proceeds would not be used for payroll? You know, that is obviously a more subtle issue and can be argued in many different ways. But after the initial rush of pure fraudsters gets flushed out, the authorities may turn their attention to more subtle and nuanced investigations and potential prosecutions. All that said, there should be very few criminal prosecutions relative to the amount of funds involved, and really the best way to protect yourself is to take the Small Business Administration's good faith standard very seriously, research and document all of your decisions, and that should go a long way to keeping you far away from any potential criminal liability. So more specifically, you'll want to have a record of the guidance documents that you were relying upon when you made the various decisions and calculations. You'll want to have those work papers documenting those analyses and the decisions and conclusions and numbers generated. If there were alternative methods of conducting the analysis, reaching the conclusions, document why you chose one alternative over another. And above all, ensure that your interpretation of the guidance is reasonable, because under the False Claims Act, if you are able to show that your interpretation of ambiguous guidance was reasonable, as long as the government cannot show that there was other official guidance warning you away from your interpretation, that should be sufficient to defeat the scienter element of a False Claims Act case, or at least it should help bring treble damages down to single damages as your worst case scenario. Also, keep in mind that the statute of limitations for False Claims Act cases can, under certain circumstances, be up to 10 years long. The loan forgiveness application itself requires records be kept for 6 years. So these issues could come up months or years later when the freshness of the analyses and the stresses that the company was under have passed, and a lot of the memory of why decisions were made and how they were done fades. So you'll want to make sure that these records are kept probably both electronically and to the extent possible in a paper file, and you'll want them kept in a manner that they will survive personnel changes and department reassignments and computer system upgrades, et cetera, so that when the time comes, either through an audit for the loans over $2 million or in some other circumstance, you'll be able to tap into these documents. And of course, contemporaneously recorded decision-making is going to be a lot more convincing to the authorities than after the fact legalese and arguments generated by a defense team as to why the company's conduct was proper. So if you can create these records and memorialize why what you did was right at the time and have those available in the future, that will be much more persuasive than trying to recreate history. Also, make sure that your records match whatever third-party payroll processors' records will state, or reports to federal or state tax agencies. And if there are discrepancies, be prepared to explain those differences. It could also be a consideration to confirm your analyses with the Small Business Administration. That may be difficult in this circumstance for lots of reasons, including the volume of inquiries the SBA is experiencing and the ever-changing nature of the guidance and being reluctant to commit to any one interpretation or not. But under certain circumstances, if you've at least put the government on notice that you are interpreting their guidance in such a way, it does make it harder for them to claim that your interpretation was unreasonable down the line. So the points on this slide are geared towards internal process and personnel management. You want to make sure that you've got the right team engaged in these analyses, making the right decisions, and that there is a consensus approach. That's obviously going to reduce the chance of dissent and possible eventual whistleblower claim down the line. Also, once those decisions have been made, you want to preserve or secure those files, working papers, just to the folks who still need them at that point in time. You really don't want to have a broader access situation for these important files. One of the Qui Tams that I worked on involved a situation where vendors had access to important company documents, and they were the ones that went out and filed a Qui Tam. So you really want to make sure that these files are secure once complete. And then again, be sensitive to whistleblower issues, and if there are adverse employment actions taken against individuals, be sure to document the reasons that those employment actions were taken to demonstrate that those were taken not because of any whistleblower activity, but for other legitimate reasons. It might also be a good time to reiterate the company's compliance profile, remind folks of hotlines, encourage folks to raise issues internally before they become a bigger problem down the line. So this slide is an effort to capture the essence of what bad documents may look like in the context of the PPP and the False Claims Act. If your files contain statements along these lines, these are the types of things that can be used to fuel the flames of a Qui Tam investigation. And beyond just the potential damage that these statements could make in their own right by existing in an email or other document, they could be indicative of a larger problem, a larger cultural issue that needs to be addressed within the company, and there may be other risky behaviors that are being undertaken that statements like this suggest may need to be investigated. So treat these indicia seriously and make sure that you're following up with your team when you see things like this and correct the record as need be for your files. The rush of this process will pass eventually, and when these issues are evaluated in the future, either months or years down the line with 20/20 hindsight, things are going to look very differently than they were today, and things that might be acceptable, excusable, understandable in today's environment will lose those protections, if you will, down the line, and you need to be sure that your documents and your files are going to be protective of the company with 20/20 hindsight being applied to them at some point in the future.
So thank you, Mike, and thank you for everyone that has joined us today. We enjoy putting on this presentation, and if you have further questions, please don't hesitate to contact us either by phone or email. Thank you.